Hi, my name is Ben Slater. I'm one of the directors and social workers at Nelly Supports, and we're on the sofa today with Debbie Leivers, one of our other social workers. Debbie is also a best interest assessor, so she's with us today to talk about DoLS. We're not talking about Barbie dolls here, are we?
No,
or
we're not.
Ken dolls or
No,
anything
we're
like
not.
that. So
No.
if any of the 100 people that have joined today are expecting to talk about the new Barbie and Ken movie, you're going to be sorely disappointed, I'm afraid. So, Debbie, we'll go straight into it because we're talking about dolls.
Yeah.
As if everyone knows what dolls is. What is dolls?
No.
What does it mean?
So, DoLS stands for Deprivation of Liberty Safeguards.
Okay.
And what that means is that someone is deprived of their liberty. For instance, they're under constant monitoring and control and not free to leave.
Okay. So
they're under constant supervision.
But that kind of sounds like prisons and prisoners and things like that.
I'm not quite sure whether anybody who's in prison is under a DoLS, to be fair.
Yeah.
I'm not quite sure because obviously they've committed a crime. That's why they're in there. However, what it means is a person lacks sufficient capacity to consent to those arrangements, whether it's for treatment in hospital or residential.
Okay, so there's a big difference
There's a
between
big
somebody
difference.
being in prison
There is a big
and somebody
difference.
being under adults. So being in prison, you're committing a crime.
Yes,
you're
have.
a baddie. And DoLS is more about treatment and care and residency and things like that. And the person has to lack capacity to agree to those.
They do.
things.
Yeah, they do. And obviously, you know, we under Article 5 of the Human Rights Act, you know, it's in regards to privacy and liberty, isn't it? So that's where it falls under.
Okay.
So yeah, because you know the person has a right to appeal against the decision. Okay. However, that's if they have sufficient capacity.
I mean, we're jumping way ahead. Yeah. But a lot of people talk about DoLS and deprivation of liberties, and they kind of miss that really important word on the end here of safeguarding.
Safeguarding, yeah.
Because a DoLS, a deprivation of liberty safeguarding order, isn't about imprisoning somebody, is it? It's not about using it as a cosh to control people or anything like that. It's there to protect people, isn't it?
Yes, it is. Yeah, it is. Yeah. For instance, you know, when I first worked in health and social care back in 2003, you know, the manager would always say, "Oh, that person's under a DoLS, that person's under a DoLS," but I never really understood what that actually meant. In my mind, I was like, "Oh, they're under a DoLS because we've got a locked door policy." Yes, there is. So you are depriving them of their liberty to leave the care home. However, it's a lot more broader than that. Yeah. You know, for instance, you know, they're under a DoLS because under the DoLS there will be recommendations from the BIA. For instance, you know, they're under a DoLS because they lack sufficient capacity to consent to medication, for instance, or they lack sufficient capacity in regards to personal care or anything like that. Okay. So it's quite broad.
There's a couple of things I just want to pick up on that. We keep saying BIA and best interest. So you're a BIA. What is that in conjunction with deprivation of liberty safeguards? What is a best interest assessor?
So a best interest assessor is able to decide whether the person is being deprived of their liberty. Okay. And we assess whether they've got a mental disorder, you know, and they lack sufficient capacity to consent to any arrangement, like care arrangements or treatment or anything like that. So as a BIA, Best Interest Assessor, we are appointed by the supervisory bodies.
And they are?
Which are the local authorities.
Okay, yeah. Okay.
So if a person's been deprived of their liberty, so they're residential, so they've gone into a care home, and it's been a you know, quick, urgent, you know, because of their risk to self and others, and they are being you know, gone into a care home.
So they have to be a risk themselves, or other being placed under adults. Or that's why somebody would be looking at that.
Yeah, that's why we'll be looking at that. Yeah. So obviously, you know, they're in a care, and then the managing authority, which will be the care home manager, she would have to apply for an urgent DoLS because they're so obviously, which is 7 days. Urgent DoLS is 7 days.
Is that seven? The DoLS last for 7 days, or somebody's got to get
7
out
days. It's got to get the last
and
7
do the assessments
days, and then they have to do the assessment as well within that time. But then the standardised DoLS is the assessment has to be completed within 21 days. And under that, obviously they'll be under the DoLS for up to 12 months.
Yeah.
However, it will be then reviewed.
Okay.
Within that time.
So just going back to what you were saying about they have to be a risk to themselves or others, that's kind of reminiscent of the Mental Health Act as well, because if you're sectioned, if you don't know this, if you're sectioned under the Mental Health Act, that's generally because you're a risk to yourself or others.
That's correct, yeah.
So there's a link there, isn't there?
There is a link,
DoLS, the MCA, and
there is. There is at the interface between the two laws. Yeah.
Okay. Yeah. But I'm assuming then, if you're sectioned under the Mental Health Act, that's because you've got capacity, but you've got mental health problem. If you're held under a DoLS, that's because you lack capacity.
Sufficient capacity.
So that's the interface.
That's the interface. Yeah.
So you're a BIA. DoLS is huge now. I mean, it's the amount of people that we see in care homes where DoLS is in place. I mean, I wouldn't even want to guesstimate the figure, but
I have got some figures actually. Yeah, I've got some figures. You'll have to excuse me because I'm not very good with numbers.
No, that's all right. I was just going to take guesstimates. So
oh right, okay. Yeah, you can take an estimate.
I reckon probably 80% of everyone in the care home.
So I'll just say, so this is.
Adults.
There is. So obviously this is from the NHS Digital Mental Capacity Act 2005, Deprivation, Liberties, Safeguard. So these are statistics from 2022 to 2023. So there was 300,765 DoLS applications.
Okay.
Which was a rise of 11% from the 19 of 14%. Completed.
So we saw an increase from last year.
We did, yeah.
But a decrease from pre-COVID.
Yeah.
That's strange.
It is strange.
Yeah.
It is strange. I'd have to unpick that a little bit more to gain some more information about that. In regards to completed applications, that stands out. I mean, I've got these statistics from about a month ago, so it may have changed since then because I went on some training. So this was 289,150 completed applications. Again, the number has increased over the last 5 years by an average of 10% per year. Cases not completed is 126,100. Again, that's a 2% rise on the previous year.
So over a year, 126,000 people have been deprived of their liberties, but the assessments haven't taken place. I mean that's. I mean those figures are huge. You're looking at just shy of, well, just over 250,000 people. I was going to say just under 500,000, but it's not. It's just over 250,000 people that are deprived of their liberties, and over 100,000 people. I'm trying to think. We're in Grantham right now. That's about half the population of Grantham being deprived of their liberties without anybody making sure that it's in their best interest, that they're being safeguarded.
I mean, there's 56% of applications were not granted. Most of these are due to the change in a person's circumstances, e.g. being discharged from a short stay in hospital.
Oh, okay. So they were in hospital, the DoLS has been applied for, and they're out of hospital.
And now they're out of hospital, And then 19% of the cases were completed within the 21-day statutory
Only 19%?
Time frame, An average for completed applications was over 156 days, compared to 153 days in the previous year.
So they have 3 weeks to get this assessment done by, and they're averaging nearly 6 months to get them done by. So I'm guessing that this is down to lack of funding, lack of resources, and lack of manpower as well. Yeah. Because to be a BIA, you have to have already qualified as either a social worker or nurse. You have to have.
You have to.
You can't just go and train to be a BIA. No. So the workforce pool as such is limited anyway.
Yeah.
And that's but so when did DoLS come out?
So I don't know whether you can remember, there was called the Bournewood case.
Okay.
Do you remember that? So that was back in December 1997, where this gentleman was being held unlawfully in a psychiatric care home and psychiatric ward care home within there. And anyway, he was banging his head against a wall. He was punching the wall, etc., etc. Anyway, so he was being deprived of his liberty. And back then, nobody ever heard of DoLS or anybody being deprived of their liberty.
So prior to Bournemouth, anyone could be. I mean, you think of things like Call the Midwife, and you see the 1950s and 1960s, and people with learning disabilities being sent to live in specialist villages and things like that. So prior to Bournemouth, anybody could just be put into a psychiatric hospital, a mental health unit, and left there for forever without anyone. And this is why it's called safeguards.
It is, because yes.
Yeah. But potentially that means that people could be left for forever without anyone checking to make sure that they should be there.
Yeah,
I mean,
even
that almost goes back to stuff like wandering womb and all of that.
It does, yeah.
That attitude of it doesn't matter.
And, you know, at all that time, they are under constant supervision and not free to leave, which is where their acid test comes in.
Okay.
Yeah.
So what's the acid test?
So the acid test is, this is under the DoLS, and the definition for that, I'll read you the correct definition for that is, the Supreme Court has now confirmed that to determine whether a person is deprived of their liberty, there are two key stage questions, which are, is a person free to leave? Is a person subject to continuous supervision and control?
Okay. So free to leave is easy to understand. Is the door locked?
Yep.
But that can be a little bit more as well, can't it?
It can.
You know, because they used to use chairs in care homes that you couldn't get out of.
Yeah, they used to restrain you.
And restrain, lap restraints and things like that. So it's more than just having locked doors.
It is, yeah.
And I speak to lots of care homes where they're like, oh no, they're free to leave, but there's a code on the door. And they're not allowed.
Exactly.
But what does supervision mean?
So supervision means, obviously, you know, they're being supervised all the time. You know, are they at risk, or are they putting anybody else at risk?
So they have to have that continuous care.
Continuous care, yeah.
So a hospital setting, they've got nurses and HCOs and things like that continuously wandering around monitoring. Yeah. So they have to be continuously monitored, continuously supervised.
Yeah.
And then if that person walks up to the care home receptionist, the hospital receptionist, and says, "Can you ring me a taxi? I want to go." The receptionist is going to say no. Yeah. If they say yes, they're not being deprived of liberty. If they say no, they're being deprived of them.
Yeah. If, for instance, a case I've recently assessed, this particular gentleman, he lacked sufficient capacity, obviously, for residency and care arrangements, and he sets off the fire alarm.
Okay.
Constantly. Because he wants to leave.
Which is understandable, and must be harrowing for the other residents in the care home. Yeah,
and I know, obviously, you know, that people say, you know, that when you're in a care home, you are quite institutionalised. I do get that. However, you know, sometimes somebody's liberty needs to be deprived for their safety.
And it goes back to that they're a risk to themselves.
Risk to themselves, yeah.
So, DoLS comes out with the Bournemouth case, and it starts to become applied.
So that was what they called the Bournemouth gap.
And then there was the Cheshire West case, wasn't there?
And
that was the next big significant thing. That changed everything, didn't it?
Yeah.
So tell us a little bit about that.
So in regards to that's when the judge, which is Lady Hale, 2014.
So 2014, so 10 years later, and essentially we're still catching up with the ramifications. That's terrible.
It is.
So Cheshire West happened. That's obviously changed everything. So your role as a best interests assessor is to go out and assess this person to make sure that they are being deprived of their liberties in their best interest, to safeguard their rights. Now I know I had a client where I was asked to go out and assess him who'd been placed in a care home very strangely by a housing authority. And I got there and he had no mental health problems, no capacity issues. There was absolutely nothing wrong with him. He'd been dropped off at this care home on a Friday evening. He didn't know where he was. Nobody had told him where he was. The care home didn't have a clue what to do with him. Weren't sure what they were allowed to tell him or not because they had no information on him. In that instance, he was being deprived of his liberties because he physically, he could have left the care home, but he wouldn't have known where to go, what to do, or anything. So we literally pulled him into my car and we took him home. So that safeguarding aspect is super important because you potentially could have people like that, people living in a care home that shouldn't be in that care home. Your job as a BIA is to make sure that they are supposed to be in the care home. So what assessments are required to do that?
So what would happen as a BIA, the supervisory body, which are the local authority, they would appoint us to complete. So there's 6 assessments under the DoLS criteria. Okay. And they are age, from what I would complete as a BIA, is age, no refusals, best interests, and mental capacity.
Okay.
That's what I would complete as
you
a BIA.
There was 6.
There was 6. The other one is the mental health, and the other one is no refusals as well.
So who does mental health?
So mental health, that will be a section 12 doctor.
Okay, so a doctor goes out to assess.
Yeah, which is like an AMP or mental health assessor. Yeah.
And that's somebody to assess their mental health problem, difficulty, isn't it? Yeah. To give a diagnosis.
Yes. Yeah. To give a diagnosis, and obviously, to see if they've got consent to go to hospital for treatment.
And that's to then tie in, I suppose, with the mental capacity act,
it is,
to evidence that impairment of mind or brain.
It is.
And I know the legislation's just flipped from stage 1 to be in stage 2, but even so, we still need some evidence of an impairment of mind or brain. And so that's why that assessment is done, to evidence that impairment. Yeah. And then you as a BIA are assessing best interest through capacity, through talking to stakeholders.
Yeah, talking to stakeholders. And also the responsible relevant person for the persons under DoLS.
So, Mr. Smith goes into a care home. Doctor goes out and evidences that he's got severe dementia. He's got progressed dementia. You go out. When you say we're talking stakeholders and representatives, and who is it you should be talking to?
So, we talk to all the stakeholders, but the most important, as a BIA, you have to make sure that there's no concerns around their lasting power of attorney or their deputy that holds deputy of their health and welfare. And, there's possibly an IMCA involved as well, which is a independent mental capacity advocate for that person. So what they will do, they will advocate for that person if, like we said before, they lack sufficient capacity to consent for their care arrangements or residency, etc. However, it can be appealed if there has been a change in circumstances, and that's where the representative relevant person comes into place.
And who would the relevant representative person? Is that right?
Yeah, that's right. Yeah.
Good. I'm glad. Who would they be? Is that somebody?
Well, they could be family.
Oh, okay.
They could be family, but they need to be a trusted person because in the past, a case I've been recently discussing with another BIA, the relevant person was not contacted.
Oh.
Because they need to be involved within the DoLS process. They were not contacted. And the reason why not contacted is that potentially there could have been a concern in regards to their involvement. Yes, they've got LPA, but this person did have lasting power of attorney over health and welfare. That's the only reason that, possibly weren't contacted. I don't know because it wasn't my case.
But those this goes back to holistic social work. It goes back to person-centered practice. The person's kept at the centre of all decision making. But to understand them, we need to talk to people around.
Of course we do.
We need to talk to family, friends, and everybody else. So as a BIA, that's what 90% of your role, isn't it? Surely to go out and talk to everybody that's involved with that person to gain as much information as you can.
And not just that, the most important thing for me as a BIE is to make sure that that person is having, their views heard.
Of course,
as well.
Yeah.
We
so
as social workers,
as a BIA, you'd go and not just assess that person's capacity, but gain their wishes and feelings
absolutely
as much as you can from that person.
Yeah. Again, when you're carrying out your assessments, it's really important that the person who you're being assessed is involved in that discussion.
Okay. So you were talking to me the other day about a case that you were involved with, where they were in a care home. I think it was right down south, and family wanted to move them from a care home down south to one further up north.
Yeah.
There was a change in county, which is always helpful, because then we have to get two local authorities talking to each other. But it was complicated through the fact that she was under a DoLS. Yeah. Do you want to just explain kind of what that case was, what happened?
So what happened? We were contacted by the family who said that they wanted to be closer near them. We worked closely with the local authority, both there and the area where this person was going to be moved to, and that took a lot of organising, a lot of liaising with each other. But anyway, so what we did what was in the person's best interest was for her to move closer to.
And how did you? What did you do to identify whether it was in her best interest?
We did a best interest checklist.
Okay.
Yeah.
So again, that the same as what BIA would do, go out and speaking to family and friends and everybody around them.
Yeah.
But so there was no need to go to the court of protection or anything like that to get the DoLS removed, or.
No, that's we had to liaise with both local authorities.
Okay.
And obviously like the supervisor.
So a fairly smooth transition.
You would have thought. You would have thought. But no, it took quite a few of us to obviously, do that, support that person with that transition.
Yeah.
Because you know yourself, even though, sometimes possibly I do lack sufficient capacity. And, when you're in your own environment, everything's familiar, isn't it? So you need to take into account how it's going to impact on that person as well when you're moving them to a different care home.
So that low level, because that's almost going to an appeal.
It is, yeah.
You're almost appealing the DoLS that was in place. You're having to change the DoLS.
Yeah.
So the client's in one care home. We're having to then work with the local authority, have conversations with them to explain that actually, look, this is the evidence that we've got to show that it'd be in the best interest for this client to be placed elsewhere. Once the person leaves care home A, goes to care home B, what happens then with DoLS? Are they placed under a DoLS? Does the DoLS transfer with them?
No, it goes so it would be the supervisory body within that area that would have to apply for the DoLS.
When we get client from point A to point B, when they move to point B, they have to go through the DoLS application again.
So what the managing authority would be the care home manager.
Right.
She would apply for an urgent DoLS.
So going back to your statistics, add those 100,000 people that are waiting for an appointment, waiting for an assessment, a BIA assessment. Some of those could potentially have already had a DoLS in place.
Yeah.
But have moved area, or that's the same if they move from one care home to another care home in the same area as well, isn't it?
Yeah, as far as I'm aware, yeah.
So they're adding on all these additional assessments for paperwork, potentially. But so if you move from one care home to another, especially if it's out of county, you're having to go through that DoLS application process again. That's incredible. So the other case I wanted to talk to you about was we're going to call him Mr. Jones, aren't we?
We are.
Who you've recently you're supporting, who we kind of wanted to talk about this because it highlighted the wrong way of doing things.
It did,
Mr. Jones ended up being arrested, didn't he?
He did, yeah. So the story was him and his wife were in their 80s. She had been detained under the Mental Health Act on a Section 3 because she got a mental disorder. Okay, she was in a hospital, and then she was given treatment. She lacked sufficient capacity, obviously, for that, so she was under a DoLS. Went into hospital, got the right treatment, and then the hospital was like, oh, okay, we've met her needs, let's look at a care home. So she went to various care homes, and I've liaised with the local authority, and they tried 14 care homes.
14?
14 care homes.
Well, she was placed in 14 care homes?
No, they contacted 14 care homes.
And all of them refused?
All of them refused because of her challenging behaviour.
Wow.
Because of her challenging behaviour. Anyway, so over the past couple of months, she's been into several care homes. Again, she was given notice because of her complex needs. So she's now she's now been placed in a care home. Where her needs are, I've been liaising with the manager, her needs are being met. However, before she went to that care home, she was at another care home, and her husband, he's got lasting power of attorney under health and welfare, and so has another family member. He took it upon himself to go to the care home and physically remove his wife. So in his eyes, he said that she got sufficient capacity, because when he said to her, do you want to come home? She said yes. So what he did is he physically removed his wife, put her in the car, got all of her things, put them in the car, and then the next minute, you know, he's been arrested under section 136.
It's interesting you say about capacity for residency, because we get a lot of phone calls in the office where DoLS and somebody like that will ring up. I want to say my mum's definitely got capacity to write a will, to decide where she lives, whatever the decision is, because she's told me this is what she wants. But capacity for residency specifically has got specific case law behind it, the specific relevant information. It's not just as simple as saying, I don't want to be here.
No. And I think in those cases, it's like before I worked in this industry, if I had a conversation, for instance, I had a conversation with my mum, and she said, yeah, I'll come home with you. I was like, right, okay, mum's got capacity. And as we all know, under the Mental Capacity Act 2005, there are, you know, the principles under the Act, and, you know, which assume to have capacity unless otherwise proven. So I would say, yeah, my mum's got capacity. And I think
because
she said, I want to go home, But you're not looking at for me, I would be like, oh, I'm not looking at the wider picture and what that, taking a holistic approach.
Well, it goes to what is the decision? You know, what are my choices? Is it saying the care home and go somewhere else? Well, what care am I going to be provided with at home? What care am I going to receive here?
Etc. You know, and what does that care look like? You know, what is the support? What support do I need? You know, can it be met? Yeah.
So capacity for residency is far more complicated. I've seen some very poor assessments where people have been asked, you know, do you enjoy the food in the hospital? What that has to do with whether you want to stay in hospital, I have no idea. So with regards to Mr. Jones, he's obviously gone about it an understandable way.
Of course,
he's upset and he's frustrated. In his head, he's got lasting power of attorney for health and welfare, so he's got the right to make these decisions if she lacks capacity. He's also arguing that she has got capacity, and he rocks up, tries to take his wife out, and ends up being arrested. Which is kind of strange, because the case you were talking about previously could have resulted in that same thing, with a family member turning up saying, well, I think it's in mum's best interest for her to come up north, we're going to bundle her in the car and take north. The difference is that you were involved, and we went through the right process to manage that situation. You're allowed to appeal a DoLS, aren't you?
You are, under court of protection under a 21A.
Because it's not forever. It's not.
No, it isn't. I mean,
you know, once you've lost, this isn't a case of if you're deprived of your liver, that's it for the rest of your life.
No. I mean, for instance, the case where we moved care home, I went to assess this lady a few weeks ago.
Okay.
And this is in regards to a different assessment. And from where she was all those last year or so to where she's now, completely different person I was assessing. Completely different. So the DoLS has now been removed.
Yeah.
However, she has sufficient capacity to remain.
Oh, so she's decided to remain
She's
in the care
decided
home.
to stay there. Yeah.
That's fantastic.
Yeah.
Well, I mean, that's fantastic that she's making that decision.
She's made that decision. Yeah. Yeah. And it's all about giving her a voice and empowering that person to make that decision.
But keeping her safe.
Safer, so when
she wasn't able to make those decisions, we could ensure that she was safe at that time for that necessary period of time.
A totally different person.
There are other people where DoLS is put in place and actually it shouldn't be put in place, or family members or somebody thinks it shouldn't be in place. So in those, I mean, we look at it two ways, don't we? We look at it on those low-level cases where we go out and we assess somebody and see if they've got capacity for residency, like your lady.
Yeah.
And she did, and that's it.
She did, yeah.
So if you go out and we assess somebody who's got capacity for residency, let's say she's in a care home, we'll leave the hospital and treatment bit later. Yeah. You go out, you assess somebody, she's under a DoLS, but you go out, she's got regained capacity, which is fantastic for residency. What happens? I mean, does she just walk straight out the door then?
No, there'd be a procedure to go through. Like I said before, you know about the relevant person, a responsible person. They would possibly, because obviously at the moment we are promoting our service for an appeals, and within that the appeals, the relevant person would probably contact us and say, how I think my mum's is being deprived of her liberty. However, she has consent. Yeah. So she would speak to them. They would then come to us. We'd go out and we'd do our assessment under the appeals. So we go out and we do an assessment for residency.
Yep.
Say, if that person has sufficient capacity, then I think that's when we apply to the Court of Protection and take it through the appeals.
Like your lady down south that moved up north, it's also about having those conversations. Get all of those done. It seems like an insurmountable task. And I know we weren't going to touch on liberty protection safeguards because who knows when that's ever going to come out. But if they change the scope from 18 years old to 16 years old, if they change it from, or they broaden the spectrum of community DoLS, you could potentially quadruple that figure.
Absolutely.
You could be looking at 1.52 million people that potentially fall into the criteria for DoLS. So it's genuinely terrifying. I don't know what the answer would be for BIAs in the future, or AMCPs as a
I like to say, when like I said, going back to 2003, I wasn't aware of how complex deprivation of liberty safeguard is. It really, and everything that, all the intricacies and implications and everything like that.
I must admit, after this, I think I want to go and have a lay down. We're going to say thank you to Debbie for today, and I think we're going to leave that as it is. Yeah. We have got we're going to take a 30-second break and have a cup of tea, and then we're going to come back for any questions and answers that you guys have. So if you would like to send those through on the messenger system on Google Meets, you're more than welcome to, and Debbie will sit here and answer all and any of your questions. Thank you
as
very
best
much.
I can. Thank you.